The House Oversight Committee has formally scheduled deposition dates for former Secretary of State Hillary Clinton, marking another chapter in the ongoing congressional oversight activities that have characterized recent political discourse in Washington. When asked for his perspective on these developments, President Donald Trump offered measured commentary that reflected both personal respect and broader political context.
Heard that the Clintons set deposition dates to testify before the House Oversight Committee. Any reaction to that related to the Epstein?
I think it's a shame, to be honest. I always liked him. Her, she's a very capable woman. She was better in debating than some of the other people, I will tell you that. She was smart woman. I hate to see it in many ways. I hate to see it. But, then I look at me. They went after me like, they wanted me to go to jail for the rest of my life. Then it turned out I was innocent, very innocent. I had a friend that said, a very smart friend, he's a very wealthy man, knows the life, streetwise guy. He said, you have to be the most honest person anywhere in the world because there's never been anybody who's been exempt.
I've always had a favorable impression of her, Trump stated. She demonstrated considerable capability during her time in public service. From a purely analytical standpoint, her debate performances were notably strong. She possessed sharp intellectual capabilities. It's genuinely unfortunate to witness these proceedings. The president then pivoted to draw parallels with his own extensive legal experiences. When I examined my own situation, the scrutiny I faced was extraordinarily intensive. There were those who pursued maximum legal consequences against me. The subsequent outcome demonstrated that the examination ultimately confirmed my position. He referenced counsel he had received from experienced advisors who noted the unprecedented nature of the investigative scrutiny applied to his circumstances.
And finally, do you think that Donald Trump should be deposed by this committee?
Absolutely. I was a lawyer, and as a lawyer, you would look for pattern and practice. If you were deposing a witness in a case that you were trying, if you were in court, what did you know about this person? What you knew could influence how you questioned that person, how you tried the case. Donald Trump has been held civilly liable for sexual assault by a jury of his peers. 9 members of a jury found him liable in the sexual assault of E. Jean.
This exchange establishes the broader framework within which current oversight activities are operating, a political environment characterized by intensive legal scrutiny applied across the political spectrum, with both major parties experiencing the procedural consequences of enhanced congressional and judicial oversight. The following analysis examines an extraordinary sequence of events that unfolded in early April 2026, when the Supreme Court heard oral arguments in a case challenging established interpretations of birthright citizenship. The case represents one of the most significant constitutional questions to reach the court in recent decades, with potential implications for hundreds of thousands of individuals born annually in the United States. According to multiple verified accounts, President Trump was present in the courtroom during portions of the oral arguments, a departure from standard practice, as sitting presidents rarely attend Supreme Court proceedings in person. Following reports that administration arguments received skeptical reception from several justices, the president departed the courtroom. Multiple journalists present characterized his demeanor as visibly distressed, with some accounts describing animated verbal expressions in the immediate aftermath. The situation escalated significantly in the early morning hours of April 5th, when President Trump published a series of posts on his social media platform, Truth Social, at approximately 1 a.m. The posts directed pointed criticism toward the Supreme Court, an institution to which he had appointed 3 of the 9 sitting justices. The timing and tone of these communications drew immediate attention from legal analysts and political observers. Constitutional scholars note that while the substantive legal questions surrounding birthright citizenship interpretation warrant serious deliberation, with credible arguments existing on multiple sides of the debate, the president's public conduct surrounding the proceedings introduced a separate dimension of concern. The established protocol for parties involved in active litigation, particularly at the Supreme Court level, emphasizes measured public communication and deference to the judicial process. The 1 a.m. timing proved particularly notable. Communications professionals and legal advisors operating at the highest levels consistently recommend against unscripted public statements during periods of emotional intensity, particularly when an individual's legal interests are actively before the court. The posts appeared to emerge from immediate emotional response rather than strategic communication planning. Examination of this incident within broader historical context reveals a documented pattern of conduct during legal proceedings that extends across multiple cases and jurisdictions. Investigative reporting from established news organizations has compiled accounts from the New York civil fraud trial and other proceedings, describing instances of visible agitation and verbal expressions that observers characterized as inconsistent with conventional courtroom decorum. Legal professionals emphasize that such behavioral patterns carry consequences beyond immediate proceedings. In high-stakes litigation, parties are generally counseled to present composed, disciplined demeanor that reinforces credibility with judicial actors. While Supreme Court justices maintain professional independence in their constitutional analysis, the broader institutional environment, including public perception, media coverage, and congressional response, is influenced by the conduct of parties before the court. The political implications of these documented episodes merit separate analysis. Campaign communications research consistently demonstrates that voter impressions of candidate temperament and institutional fitness significantly influence electoral outcomes, particularly among persuadable voters in competitive jurisdictions. Visual documentation of emotional responses under pressure provides opposition campaigns with material that requires no editorial manipulation to present as evidence of temperament concerns. Democratic campaign strategists are reportedly incorporating footage and documentation from the April 2026 Supreme Court episode into communications planning for the approaching midterm election cycle. The material includes courtroom departure footage, social media screenshots, and verified journalistic accounts of the president's demeanor, content that opposition researchers value for its direct, unfiltered nature. Political scientists studying presidential behavior note that individual episodes can often be contextualized as exceptional circumstances. However, when multiple instances follow consistent behavioral patterns across different proceedings and time periods, the explanatory framework shifts from isolated incidents to identifiable characteristics. The documented pattern of visible agitation during legal proceedings now includes entries from civil litigation, criminal proceedings, and Supreme Court arguments, a breadth that complicates dismissal as circumstance-specific reactions. The Birthright Citizenship case itself carries constitutional significance that extends beyond immediate political considerations. The 14th Amendment Citizenship Clause, ratified in 1868, has provided the constitutional foundation for automatic citizenship for individuals born on United States soil for over 150 years. The Trump administration's challenge to this interpretation, if successful, would represent one of the most substantial modifications to citizenship doctrine in American constitutional history. Lower federal courts have uniformly blocked implementation of the administration's executive action, creating the legal pathway to Supreme Court review. During April 1st oral arguments, justices reportedly expressed skepticism towards several administration arguments, though court observers caution against predicting outcomes based solely on questioning patterns during arguments. The administration's public conduct surrounding the case introduces variables that legal strategists generally seek to minimize. Supreme Court proceedings, while formally insulated from direct public pressure, operate within broader political and media ecosystems that influence how decisions are received and implemented. When parties to litigation publicly criticize the court during active deliberation, they risk complicating the environment in which their legal positions are evaluated. Looking forward, several indicators will clarify the lasting significance of this episode. The timing of the Supreme Court's eventual decision, whether before or after the November midterm elections, will substantially influence political framing. A decision adverse to the administration would likely be reported within the context of the April conduct, potentially reinforcing narratives about procedural management. Conversely, a favorable ruling would provide administration advocates with argument that legal strategy succeeded despite surrounding controversy. Campaign advertising patterns will provide additional indication of how opposition strategists assess the material's persuasive value. The deployment of Supreme Court episode footage in paid media, particularly in competitive suburban districts where moderate voters determine electoral outcomes, would demonstrate confidence in temperament-based persuasion strategies. Conversely, limited advertising utilization would suggest assessment that the material primarily mobilizes existing opposition rather than persuading undecided voters. The most consequential forward-looking consideration involves whether similar conduct patterns emerge during subsequent legal proceedings. The administration faces ongoing legal challenges across multiple jurisdictions and subject areas. Each additional instance of visible emotional response during institutional proceedings strengthens the pattern documentation and reduces available explanatory alternatives. Legal professionals across the political spectrum emphasize that composed, disciplined conduct serves litigants' interests regardless of underlying political orientation. The fundamental question emerging from this analysis concerns institutional management under pressure. The presidency, by constitutional design, intersects with judicial authority across multiple dimensions: appointments, policy implementation, and direct litigation interests. How occupants of that office conduct themselves during these intersections carries implications for both immediate legal outcomes and longer-term institutional relationships. The April 2026 sequence, courtroom attendance, reported departure under visible distress, and early morning social media criticism of the deciding institution represents a departure from conventional presidential conduct during active Supreme Court proceedings. Whether this departure reflects isolated circumstances or indicative patterns will become clearer as additional proceedings unfold across the administration's remaining tenure. Constitutional governance ultimately depends upon institutional actors maintaining appropriate relationships across branches, even during periods of intense disagreement. The coming months will demonstrate whether the dynamics observed in April remain exceptional or establish new patterns in executive-judicial relations, with consequences extending well beyond any single case or administration. This analysis is based on verified reporting from multiple journalistic sources, court records, and publicly available social media documentation. Constitutional interpretation questions referenced herein reflect ongoing scholarly debate without predetermined resolution.